Welcome to video 3. This is my second attempt because for some reason the slides would not advance, so I am using them not in presentation mode, but in edit mode. So hopefully this doesn't, hurt the clarity or quality of this. We've talked about different aspects of Chapter 5 that could be used in hacking back or to arrest hackers, EEA. This lecture's on CFAA and CISA. Now, I'm not going to spend a lot of time on CISA because we will be having... Come on, why is this doing this? This is ridiculous. Because we're going to be talking about this later on when we talk about the executive orders and critical infrastructure. But I just want to highlight a few points. First of all, when you look into law, like anything else, always look what goes on Friday afternoons or holiday weeks. So this law was signed into legislation by President Obama 1 week before Christmas, kind of like who noticed. And it was actually in a spending bill. And if you're not from the United States, only in the United States can we have appropriations bills with little things stuck in on them. But basically, it wanted to share information across different companies or industries. And in the United States, we have very strong laws against antitrust. So we can't sometimes, if there's a few oil companies, you can't easily share information because of the antitrust. But basically, the thinking went with this. If we think we're being hacked and we're a major oil company, we should be able to share information with other major oil companies because this could be a synchronized attack. This could be of critical nature in the United States. A lot of good reasons behind this law. But what happened is it didn't work out like we thought. It helped spur EU passing GDPR, which we'll talk about later. Some of the criticisms is that when you share this kind of data, for instance, if you look up here, you can share internet traffic information between, different companies, then are you really protecting personal identifying information? And then there was this fear that this was the government then monitoring access to information. Now, again, you have to remember two words, Edward Snowden, who was coming out about this time. As I said, we'll talk about this later. But I want to put that as one law that you need to think about. These are the laws. We're going to talk about CFAA. We're going to talk about DMCA. We've talked about EEA. We talked a little bit about the Trade Secrets Act. Patent law. This is all the different ways that if you risk reverse engineering or hacking back, you can be brought into courts. The important thing to remember is what is being stolen. If it's a trade secret, it comes under the Electronic Espionage Act and the Trade Secrets Act. If it's a patent, you do have federal laws protecting it, but your civil liberties, your civil rights will be in patent law. Whereas a trade secret, your civil, not criminal, civil is going to be under these other laws. Then you have all these other things. I'm not going to go too much into the trade secrets law. On your own, you might want to just check this out. It's 204 pages of all the state trade secrets law, which we tried to unify in 2016 with the passage of the Trade Secrets Act. Now, we've talked a little bit about hacking back, that when we hack back and we hack back against an individual or an entity, that is, we go on the offensive, that's the rule of law. But when we hack back against something that turns out to be a nation state, that's a military-style response, or it used to be called rule of war. Now it's called rule of laws of armed conflict. And the laws of armed conflict, they're not really legally binding always. I mean, it's the Geneva Convention, it's different treaties we've signed. So first of all, when you hack back, you want to be careful you don't escalate. That you think you're hacking back against an individual or an entity, but it's really a nation state. So you're basically, have brought it, not the old thing about bringing a knife to a gunfight, but bringing a knife to a fight with a country that's basically going to have a large air force against your knife fight. So we want to be careful about this, and this is one of the risks. The other risk is proper attribution. How do I know who is really behind the attack? Then there's this gray area of hacking back versus attacking back versus deceiving attackers. There's a very black and white line between offense and defense in some respects. And we know that we can properly defend ourselves. Then further out, we have a line of what we can do that we know is clearly illegal. The problem is what's between. Some things that we may interpret as being illegal, others may not interpret to be illegal. So the hacking back, when does attacking back, going from defense to offense, turn into a criminal or civil matter? And if you're just deceiving the attackers, there's one school of thought that says this is another notion of hacking back that shouldn't be allowed. Others are like, no, you're deceiving the hackers. So I'm going to spend the rest of this video on the CFAA. Literally, it was passed in response to a movie called War Games that was put out in 1983. Now, I want you to think about this next part of the lecture, the analysis, the legal analysis, okay? What it has given us is a legal definition of computer and protected computer. But the law is written to say it is illegal to access a computer where you lack authorization or you are, let me bring this up. Should have done this earlier. And of course, this is going to be a pain since I'm only working with part of the, no, this is ridiculous. All right, on your own, will you look through this? I'll do a separate video. I'm having some issues with Snagit. But look through this, and I will do this in a subsequent video. All right, so we go back to the CFAA, who can investigate the FBI and the Secret Service. Secret Service is part of the Treasury Department. It's kind of odd, I know, but it is FBI is like our police station for the country. So basically what I was trying to show you on the website was the CFAA is illegal to intentionally access a computer without authorization or in excess of authorization. And the law does not explain what without authorization actually means. Okay, so this is going to be the legal analysis that I'm going to show you in a minute. But listen up. When a word is not defined precisely in law, we leave it to its common ordinary meaning. Okay, so the word computer is defined in law, as you can see here, by 18 U.S.C. section 1030 E1. The term computer, and it gives you this long definition, and the term protected in computer refers to specific government and financial computers. You have to remember this was passed in the early 80s when the big concerns were protecting our financial. And, but it doesn't, while it makes it illegal to intentionally access a computer without authorization or in excess of authorization, it does not define what that actually means. And we're going to see that in the analysis. By the way, our national cyber strategy released last September by President Trump we are now doing forward defense, which is a euphemism for being on the offense. Before this, and I haven't checked it recently because I think it's probably dead now with that national strategy, we did have laws that were going around the Senate and the House for ACDC, Active Cyber Defense Certainty Act. Two laws I want to bring up in relationship to this. Both are 2011. The first went to the Eighth Circuit. And the United States Court of the United States Court of Appeals for the Eighth Circuit had to determine if a cell phone was a computer to bring an issue under the CFAA. In this case, Mr. Kramer was in texting with a person that he knew was under the age of 15, or was 15, which was under the legal age of consent, although quite frankly it would not have mattered. Anytime someone engages in a sexual activity with a person of under the statutory age, it's still, saying you didn't know that person was only 15 is no defense. But he was charged with transporting a minor across state lines. I believe she was in Louisiana. He was in Missouri. They're texting back and forth. He comes down to Louisiana. He takes her. He drugs her. He gives her alcohol. He does some things that was sexual in manner. But there wasn't that much of a state law about it. So he was charged under the CFAA. Now, the important thing to remember is this is not what the CFAA was designed for. However, at this time, we didn't have really good laws on protecting children from things like sexting and on the phone. There were laws that she was underage. But for him to be charged with this, they had to prove that he had accessed a computer to communicate with her. So it became the legal issue. Now, remember how I told you before, technology is one issue, legal's another. The legal issue became, is the cell phone a computing device? Is it by law a computer? Now, be sure you understand, he was not charged under the CFAA. He was charged under another law, but they deferred to the CFAA for the definition of computer. And I may have confused you a few minutes ago, forget what I said. He was not charged under the CFAA, but the definition of CFAA was used in this decision. So he was charged under a law that said transporting a minor across state lines to engage in illegal sexual activities. As part of that, they had to prove that he had done this intentionally and he had used his phone. So even though he was not under the CFAA, they used the definition of the CFAA to define computer. And they began their appellate decision with a quote from Stephen Jobs, everything has a computer in it nowadays. All right? So let's be clear. Sorry if I confused you. Wasn't charged under the CFAA, but they used that definition in the legal analysis. We're talking about the legal analysis now. Same year, United States v. Kane. This one never made it past the magistrate court. The federal magistrate dismissed the charges because two guys had found a software bug in a poker machine, and it did not, and they used it, and they figured out that if they ran this certain sequence, it would pay out. And so they, of course, the casino has people watching, and so they began to look at this. And by the way, you're going to want to look at this as well, which of course I can't bring up since I'm doing this in edit mode. But so they used this, they found a bug in the poker machine, they made a bunch of money, and they were brought under the statute. And the court ruled it was not being connected to the internet. Huh? What? Well, they were charged in the CFAA as use of a protected computer in interstate commerce and exceeds authorization. And this again demonstrates how the CFAA is using a situation beyond hacking that it was intended. So the court ruled, hey, it's not connected to the internet, and if it's not connected to the internet, there is no interstate commerce, and exceeds authorization, it's not a computer. The court ruled that a poker machine is not a computer because it fails this definition of computer. All right? And I've talked about Aaron Schwartz before. He was charged under the CFAA. It would have been draconian, and he committed suicide. And so every few years they do the Aaron Schwartz law, which never gets anywhere. All right, so when we talk about CFAA, we want to talk about that the violations are clearly, if they are code-based, if it circumvents computer code, if I get something that's going to get around your protection mechanism, clearly falls under the CFAA. Where the courts disagree, if it's contract-based, if it's a user, a terms of service or an end-user license agreement, the courts are, does this come under CFAA? And then there's this whole idea of public policy and norms-based, and if it's contrary to societal expectations. So the disagreement, again, in the circuits, if this falls under the CFAA. So, for instance, in the Ninth Circuit, there's a very narrow reading of exceeds authorized access. And again, here's the legal analysis coming in. Exceeds authorization. Is it defined in the law? No. Then we go to its plain, ordinary meaning. It is not a technical term, and it simply means to access a protected computer without permission. This comes from a case, Nozzle, who worked for Korn Ferry, and he did not access the computer, but what he did is he got employees after he left to access the computer and pass data to him. And so the Ninth Circuit will typically say you're liable only if the initial access was not permitted. The First and the Fifth Circuits are broader. They have a broader meaning. I can't go to this, but you might want to look at this. This was a case in Houston a few years ago, where someone made a lot of money, left a back door, waited for his non-compete to expire, and then went in and tried to escape the data and was arrested. All right, so under CFAA, what can happen? You can have criminal. You have 7 sections. You can be tried multiple times. You can have one event that you might have brought 5 counts by different sections. Each of these is a separate crime. They have asset forfeiture. It's long prison terms. It's big fines. And so it's not impossible, like Mr. Schwartz found, to have one event and be looking at something like 35 years. I want to leave it at that. On your own, please go back to the websites I did not go to and look through those. Thank you, and we'll move on to our last video for this chapter.